Hello everyone, my name is Sarah and this is the presentation on the duty of care in negligence. So what we're looking at, the full title, the liability and negligence for injury to people and damage to property. So hopefully you've watched the first video about what is negligence. That's a real oversimplification of what we're going to be looking at today. So just to remind you, what we're looking at is it's the breach of a legal duty to take care resulting in damage to the claimant which was not desired by the defendant. So the first thing I want you to do is put out of your head anything to do with criminal law. We're not talking about you kill somebody and they go to prison. That's not what we're looking at here. We're looking at really the stuff that comes before that. So it's not arguably as bad, but it results in some damage to property possibly, or damage to an individual, their body, their person. It might result in death, but you don't have the necessary mental element, mens rea, the intention element for a criminal matter. So we're not talking about crime here. So put any criminal terminology to one side. So you'll remember from the previous presentation, which hopefully you've watched. If you haven't, I would pause this one here. I'd go back to that previous one. We're simply looking at three main elements, and today's presentation is going to focus on the first one. So negligence is built in three layers. First of all, you have to owe a duty to somebody, and today we're going to find out how you go about doing that. You've got to breach that duty, so you've got to fall below the standard which is expected of you to conform to that duty. And importantly, that breach has got to cause damage. If you don't have damage, then it's no harm, no foul. So today's presentation is going to be based around this diagram. It'd be a good idea for you to pause the video here and take down your own copy of this, because this is what it's all going to be based around. It would be a good idea to leave yourself a fair gap between each of the boxes so that you can write the notes down that you need. But this presentation will give you everything that you need to know about duty of care. So let's start at the top by having a look at where it all started, and in fact where the law of negligence all started, which is a case called Donahue and Stevenson. So Donahue and Stevenson, if I was a betting person, which I'm not, but if I were, I would bet that when you go to university to study law, this will be one of, if not the first case you ever come across. So do yourself a favour, know it inside out, and really show off in that first lecture. So the facts of this case, it's from 1932 and it's a Scottish case. Mrs. Donahue was in a cafe with her friend, and she was drinking from a bottle of ginger beer from an opaque bottle, so you couldn't see straight through it, and this had been bought by her friend for her. She was also eating it with ice cream. The idea is you put the ice cream in, you put the ginger beer over the top. It's very fashionable, sounds disgusting, but apparently it's very nice. She had already eaten and drank some of her ginger beer ice cream concoction when she topped it up and out fell a decomposed snail. The shock of the snail, together with the fact that she had already consumed some of it, led Mrs. Donahue to suffer some quite unpleasant tummy problems as well as shock, understandably. So this is what the judges said, because Mrs. Donahue had a problem in that she hadn't bought the product. She hadn't bought the ginger beer, her friend had. And the House of Lords decided, this was a big significant case that went to the House of Lords. There were 5 judges that heard it, and by a majority of 3 to 2, the legal duty of care could be owed by a manufacturer to a consumer, even though no contractual duty existed. Prior to this, if you hadn't bought it, then you were owed no duty. So gifts that were deadly, there was not a lot that could be done about that. And the judgments of Lord Aitken and Lord Macmillan suggested that the legal duty of care could exist beyond that owed by a manufacturer to a consumer. Lord Aitken gave us what was known as the neighbour principle, which imposes this universal duty to take care. So you may be familiar with the idea of love thy neighbour, the biblical principle. Well, Lord Aitken said if that's the biblical principle, then the legal principle is that you will not injure your neighbour. And Lord Macmillan stated that the categories of negligence are never closed. Now that's quite a can of worms that when you look at evaluating this area of law, you need to have a think about. But what they were saying was it was no longer acceptable to say, well, they didn't buy it, so I'm not responsible for the fact that they got hurt by my product. So having decided that the legal duty of care could be owed, the House of Lords sent the case back to the Scottish courts to be tried on the facts using the duty of care principles. Unfortunately, the trial never took place because Stevenson died, and Mrs. Donoghue was given a significant sum of money in an out-of-court settlement, and it's around £200. But this was 1932, so for a bit of a tummy upset and the shock of eating a snail, £200 was a pretty good payout. So this neighbour principle, what I'd like you to do is have a look out of the window. Now, this can't be any old window. Ideally, you need to be able to see people and cars and houses out of it. If you live in the middle of the countryside, it's probably not going to work. And I want you to think about how many categories of neighbour you can see. If you don't have a suitable window, I've included a picture of Prague in the Czech Republic. So have a think about neighbours that you can see. So hopefully you've found a window, you've looked out of it for a little while, wondered about quite exactly what it is you are doing. So if your neighbour is somebody who is directly affected by your acts or omissions, so somebody who's affected by what you can do, if we just look at the picture that I've included, you've got various cars which I assume would have drivers. The drivers owe a duty to one another. You can't hurt another car driver. You owe a duty to pedestrians. There are various pedestrians wandering down the middle of the road. You've also got cyclists who you would owe a duty to, and all of those people would also owe a duty to each other. And quite simply, you owe a duty to your actual neighbours. You can't, for example, put loads of rubbish outside their front door so that they fall over. You can't damage their property by something that you do on your property. So essentially, everybody that you see in that picture and every category of person who could be in that picture owes a duty to everybody else. Now that's a bit of a difficulty because it's almost infinite. If you imagine you get on the bus and you sneeze, and your germs are going to affect the person who sits next to you. They may take it home and they may give it to their children, who may go into school and give it to their classmates, who may go home and give it to their parents, which may end up losing their parents a lucrative job interview, so they don't get the job, so they lose the house. Now, some might argue that if you were negligent in the way that you sneezed, if you didn't cover your mouth or anything like that, that maybe you owe a duty to the person that you were sitting next to. But are you really responsible for all of those people? No, probably not. And the law is clarified in this respect by the case of Caparo Industries and Diekman from 1990. So the facts of the case: Caparo wanted to take over a company called Fidelity. And Caparo based this decision on a set of accounts which was prepared by Diekman, who was an auditor. So Diekman's job was to have a look at Fidelity and prepare a set of accounts to give to shareholders and to other interested parties, which gave an indication as to how well Fidelity was doing as a company. The accounts that they prepared didn't fully demonstrate how dire the situation with Fidelity was. And having relied on the accounts that were prepared, Caparo Industries bought Fidelity and then realised that it was a terrible, horrible mistake when they fully appreciated the picture. And they said, we would never have bought this company if the accounts had been accurate. And this is an area of law called negligent misstatement, which you'll probably be pleased to know I'm not going to go into now. And the decision of the House of Lords was based on the fact that there wasn't sufficient proximity, sufficient closeness in the relationship between the auditors and the shareholders. This means that the duty of care owed by the auditor who prepared the accounts was to the original company, Fidelity, rather than the shareholders and everybody else down the chain who was relying on this. So that's the facts of the case. The important thing that came out of Caparo Industries and Diekman was a three-part test which clarified the neighbour principle and reduced the scope of who you owe a duty to. So in order to establish a duty of care, you must prove each of these three things. You've got to have all of them. So the harm must be reasonably foreseeable as a result of the defendant's conduct. The parties must be in a relationship of proximity. They must be sufficiently close. And it must be fair, just and reasonable to impose liability. So we're coming back to this diagram again because I want you to see where we've got to. So we've had a look at Donoghue and Stevenson and you understand the neighbour principle and where the idea of duty of care came from. Now we're going to have a look at the three-part test in Caparo and Diekman. Was the harm reasonably foreseeable? Was there sufficient proximity? And was it fair, just and reasonable? So looking first at was the harm reasonably foreseeable, this is could you guess what would have happened? A good example of this I always give is the film Snakes on a Plane. Could you guess what was going to happen in Snakes on a Plane? Well, if you have not seen it, I'm going to give you some spoilers. There are some snakes and they get onto a plane and carnage ensues. It's like that. Can you guess what is going to happen or what sorts of things might happen? You don't have to be dead on, you don't have to say exactly well this happens 20 minutes in, but you need to understand the sorts of things that may happen. And this can be seen in the case of Kent and Griffiths. So an ambulance is called to somebody who is having an asthma attack and it fails to arrive in good time, and guess what, the person gets a lot worse. And the court said that this was sufficiently foreseeable, and it was foreseeable that the claimant would suffer some injury due to the delay, which they did. Borehill and Young, the outcome was not foreseeable. In this particular case, there was a pregnant lady who heard a fatal accident. So she heard the collision, and sometime later on, after the body had been taken away, she passes by the scene of the accident where there is still quite a lot of carnage, there's quite a lot of blood, and she later loses the baby. And the court held that it was not foreseeable, the harm to the baby, because she did not actually see the accident, she heard it and she saw the aftermath. So that was not foreseeable. So you also require sufficient proximity. Sometimes we'll describe this as closeness. I don't think that's grammatically correct, but it sums up the situation perfectly. So you've got to be sufficiently close in time, space and relationship. So an example where there was sufficient proximity is Home Office and Dorset Yacht Club from 1970. In this case, a group of young people from a Young Offenders Institute managed to escape the custody of their officers, broke into a yacht club and played on the boats, stole boats, trashed things, damaged things. And the Home Office said, well, it wasn't our officers, we didn't do it, it was them. It was the young offenders. And the court said, no, there was sufficient proximity. You had a sufficiently close relationship between the Home Office, who were in charge of the young offenders, and the boat owners. And so there was sufficient closeness between them. Caparo and Diekman, as we said before, there wasn't sufficient proximity because it was too remote. There was sufficient proximity between the auditor and the company, but there wasn't sufficient proximity between the auditor and the shareholder. And finally, was it fair, just, and reasonable to impose a duty? Now, this test primarily applies to emergency services and rescuers. The idea being, if a police officer or a firefighter is rescuing you from a situation, and in doing so you're being carried out of a burning building, they knock you on the head on the way out and they cut your forehead, you can't sue them because they're getting you out of a worse situation. It wouldn't be fair, just, or reasonable to then sue them, would it? And this can be seen in the case of Hill and the Chief Constable of West Yorkshire, where there was no duty of care. The parents of one of the Yorkshire Ripper victims tried to sue the police for not protecting their daughter and allowing her to get killed. And the court said, albeit with a heavy heart, the police don't owe a duty to everyone. They don't owe a duty to prevent every crime from happening. Even though it would be great if they could, it's not practical, and it wouldn't be fair, just, or reasonable to sue them in that circumstances. However, Capital and Hampshire County Council, there was a duty of care. In this particular case, we had firefighters fighting a serious burning building. When they arrived at the scene, they switched off the sprinkler system, but then they struggled to find the original source of the fire, thinking that they would be able to tackle it very quickly, which is why they switched the sprinklers off. What actually happened was the fire continued to rage for quite some time. They later realised this, reactivated the sprinkler system, but it was too late and the damage was done. And actually the building was completely trashed, whereas if the sprinklers had been left on, there would have been a lot less damage. So in that particular case, there was a duty of care because it was fair, just, and reasonable to impose the duty in that case. So hopefully you have a diagram that looks something like this, and you have also got the notes underneath it. So if you are answering a question on this, you might just be asked to explain duty of care in the context of the law of negligence, and you've got your notes there. You may be asked to explain how it works in a scenario question. I am going to do a video on how to do a scenario question, but essentially what you would do is you would explain Donahue and Stevenson and the neighbour principle, and then apply that to your scenario. In this case, the claimant is the neighbour of the defendant. You would then explain the Caparo test and say that there are 3 parts to it. You would look at, was the harm reasonably foreseeable, and you would make a judgment call on, could you guess that that outcome may have occurred. So if, for example, we look at your defendant was driving too fast, they met the curb and they hit the claimant. Was it foreseeable that if you drive too quickly, you might hurt somebody? Well, yes, it is. You will then move on to, is there sufficient proximity in time, space, and relationship? And when you have a situation where your claimant and your defendant are in the same place at the same time, doing the same category of thing, so they're both road users, they're both in the same cafe, they're both in the same shop, they're both doing the same job, then there will probably be sufficient proximity. And finally, you'll look at, is it fair, just, and reasonable? And if your defendant is not a rescuer or the police or the fire service or somebody in that category, then it will be fair, just, and reasonable to impose a duty, and you will be able to conclude that yes, your defendant owed a duty of care to the claimant. Hopefully that's nice and clear. I would suggest you now go through and write these notes up so that they're nice and neat, and I will see you back here to have a look at breach of duty next time. Thanks for listening.